Our next speaker is Nandita Rao. Nandita Rao is a lawyer based in New Delhi. She's one of our most distinguished advocates in the field of human rights and welfare legislation. She played a very important role in Sagarika's case when Sagarika came back to India and her children were sent back to India but not to her. They were given in care of their paternal uncle. He was a bachelor in his 30s. He had his own life to live. And it became very clear that, no one in India would have any doubt how ridiculous this grand Norwegian solution was, but it became very clear in the diplomatic negotiation between India and Norway on this case that Norway needed a face saver, and so the Indian side gave in. But Sagarika's husband chose to stay on in Norway, and her in-laws refused access to the babies, and so now Sagarika had a job on her hands persuading the Indian authorities to return the children to her. And this is where we turn to Nandita. As an expert in the Indian child welfare system, she gave crucial legal advice to Sagarika and was absolutely essential in her eventual victory. And since then, Nandita has worked with me on many such cases from around the world. She has appeared online in the courts of the United Kingdom for families there with taken children. And she does all this work for free. She refuses to take any payment. Put it together, ladies and gentlemen, for Nandita Rao.
Thank you so much, Suranya. But I think Suranya is more the lawyer than me. She just eggs me on and then I find the sections, but the ideas are all hers. So before I start, Sagarika, Shatrughan Sinha ji, Mr. Mani Shankar Iyer, Suranya, and all the mothers. After having worked on so many of these cases with Suranya, it's still so heart-wrenching to hear these cries. And in court, we are blamed for showing our emotion. So to start with, the courtroom is not a place where children's issues should be decided. Because if we have left our emotions outside as judges and as lawyers and as people, then we can't possibly be looking at the child or speaking at the child or understanding what is in the best interest of the child. Because you have to have empathy and emotions to understand what is in the best interest of the child. So one of the biggest criticisms of me by judges is that she's a lawyer who starts crying. But I don't think you can do human rights litigation without doing that. So we have limited time and we have a lot of speakers. So I'll quickly come. The topic that Suranya has chosen is an extremely good topic: man, woman and law. So first, the law that applied to man, woman and child was the family law. In India, it's personal law. But even in the Western world, it was their personal law was also very conservative. So when it came to child custody, the battle was between the man and the woman. Traditional law gave man all the powers over the child, even though the woman was the birther and the woman was the nurturer. So 30 years, mothers fought men to get a right to their child. Otherwise, it was he's the natural guardian, he has the money, servants can look after the child. So the moment a man was not interested in his wife, the children were taken and given. So mothers fought and fought and fought, and today the law has been changed that a mother is also a natural guardian and the wishes of the child and the best interest of the child is seen, and man and woman have been sort of equalized in personal law when it comes to custody of the children. And just as mothers of our parents' generations had won this battle within the family, in the year 2000 in India, but I think sometime in the 70s in the West, the state suddenly entered into the fight with the family. So the battle for children from being between mothers and fathers, where fathers had the upper hand, the battle for children became between the state and the family. Because the child welfare department started knocking into everybody's houses and seeing, oh, are you parenting well? Many of them may not even have had children of their own. So they don't even know what they are checking for, what they are looking for. And the whole thing is totally subjective. That whether you are the good parent or you are the bad parent, and the state got the right to take away the child from both the parents and make a child with parents an orphan. Snatching away not only the child from his family, but from all his relatives. Uncles, grandparents, cousins, friends, family friends, inheritance, language, culture. So, in India, in the year 2000, this interference of the state came through Juvenile Justice Act 2000, where for the first time, till now, Juvenile Justice Act was only for children who were in conflict with the law, who were caught in some offense, who committed some offense. But now in the year 2000, for the first time, this special language came in, children in need of care and protection, which meant till now the state could not come and take your child because the personal law was only between family members. And under Guardians and Ward Act, suppose somebody was being really bad to their children, a neighbor or a grandmother or a grandfather or a relative could go to the guardian's court and say, look, this child is being treated so badly, please. And in the Guardians and Wards Act, they had to make all the family members a party. So Guardians and Ward Act did protect children whose parents were torturing them. But it was protected through kith and kin, through neighbor, through friend, not through the State Department. But Juvenile Justice Act, through child rights activists, brought in the state that children in need of care and protection included people whose parents were unfit to look after the children and keep them safe. And unfit is a very broad word. Unfit can be anything. You can do anything and be declared unfit. Like many times if we start crying in a rape case, we are told we are unfit to be lawyers. So unfit is very subjective. If you care, you are unfit. So, but fortunately, I will applaud our Indian humanity of our culture, that who is the person to declare unfit? It is a child welfare committee. So it is not the judiciary, it is not the family court, it is people appointed by the government who are social workers, who are gynecologists, who are people related with children. But to the best of my knowledge, the first case in which foster care, Child Welfare Committee took an order of foster case was Sagarika's case, where our Child Welfare Committee took the children back from the uncle and gave it to the mother. So I think we should be very proud of our Indian Child Welfare Committees, that they still care about the child, they still care about the mother, they still care to see in the facts of the case. And I was also very happy to note when COVID came last year in 2022, so that time suddenly people petitioned the High Court that, Juvenile Justice Care Act from 2000 has foster care system. And for 20 years, government has not recruited any foster carers. That is also an example that our child welfare committees were not focusing on snatching the children and giving them in foster care, because we did not need a list of foster carers. So the child welfare committees were doing what Suranya has coined a beautiful word, kinship care, and using the provision of sponsorship. That if a family has a problem, first try to understand, are they pathological people who are dangerous to the children? Or is it because the man, the father, has lost his job? Is it because the mother who was looking after the children has got some disease? Is it because the grandmother who was supporting while both the parents were going out to work has died? And if it is some circumstance in the family that is causing the lack of care that the child is getting, give the family money instead of taking the child out of the family and putting it into some other family and paying that family money. In foster care is not for free. The foster carer is not going out of his own love and saying, okay, I will look after this child. Foster care is a paid service. So, in our law in India, we have sponsorship. So, our child welfare committees have been focusing on supporting the family in their time of crisis to be able to be better parents. So, I would urge our parliamentarians and our government that please take Sagarika's example. Don't let our child welfare committees turn into evil Barnavans, and please promote this thinking that support kinship care, support the family, give them whatever money, health care, whatever they need to become better parents. And with my salute to Sagarika and to all the mothers, including my own, thank you for leading this battle.